Good morning, my name is Tiokon Ken, the PA to the CEO.
Good morning, Chair and members. My name is Abdi Malim, Manager of Voter Registration.
And lastly, good morning, Chairs. My name is Crispin Owiye, Director Legal Services, IBC. Thank you.
Thank you. CEO will give you a maximum of 20 minutes. We don't need you to go through line by line the entire document that you have presented, since you had filed with our secretariat your memoranda. We would just want you to give what would possibly be an executive summary or exposition of that memoranda on the very salient issues that you had in your presentation.
Thank you. Once again, honorable members, for inviting the Secretariat of the Commission to come and give its oral submission on the matters that are of interest to the Commission. In this presentation, we'll just be focusing on 3 thematic areas. 2 of them are actually in the dialogue committee agenda, and 1 is we consider it as if it is outside the agenda. So there will be 1 is outstanding constitutional matters, which touches on 2/3 gender rule, electoral justice, and related matters, and the additional 1 is what we are referring to other matters that may not necessarily have been in the agenda. So I'll go straight away to 2/3 gender rule because I have very little time to present. Section 25 of the IBC Act 2011 requires the Commission to observe Article 81. IBC implemented the judgment of High Court in Katiba Institute versus in High Court in Katiba Institute versus IBC 2017 EKLR, which directed political parties to comply with Article 10, 19, 20, 27, 28, 56, and 91, sub-Article 1 of the Constitution, on fundamental rights, equality, and non-discrimination. Following this judgment, the IBC devised administrative mechanisms to ensure realization of the 2/3 gender principle during the nomination process for the 2022 general election. Currently, the IBC is represented in the multi-sectoral working group on the 2/3 gender principle, which was constituted and gazetted by the Ministry of Public Service, Youth and Gender Affairs. Issues related to this area, honorable members, is that on 11th May 2022, the High Court suspended the implementation of 2/3 gender principle in the nomination of candidates for the 9th August 2022 general election, thereby thwarting the Commission's effort to facilitate the realization of 2/3 gender rule. Further, there is absence of enabling law to operationalize the 2/3 gender principle. It is our considered view that Parliament needs to consider enacting into statutory law the 2/3 gender rule in compliance with Article 81 of the Constitution. The second thematic area is on restructuring and reconstitution of the IBC. The IBC understands restructuring to mean making necessary changes to its structure, systems, and processes to achieve its mandate effectively and efficiently. On the other hand, reconstitution is onboarding of members of the Commission arising from vacancies at the governance level. Section 11A of the IBC Act 2011 details the relationship between the Commission and Secretariat. The Commission consists of the chairperson and 6 members appointed by the President after competitive recruitment pursuant to Article 250 sub-Article 4 of the Constitution and the provisions of Section 5 of the IBC Act 2011. The Commission is responsible for formulation of policy and strategy of the Commission, as well as oversighting the Secretariat. The Secretariat performs the day-to-day administrative functions of the Commission and implements the policies and strategies formulated by the Commission. In line with Section 12 of the IBC Act 2011, the Commission has created directorates, units, and field offices to achieve its mandate. Currently, the Commission has devolved its function to all the 47 county and 290 constituency offices. Over time, and in accordance with the Independent Review Commission, commonly referred to as Kriegler Commission, the Commission has continued to recruit professional and permanent staff and to build their capacity in election management. The current structure of the IBC has delivered successfully on its mandate. The Commission periodically reviews its structures and systems and processes to address the internal as well as external environment that affects it. In particular, the Commission uses post-election evaluation exercise that is largely stakeholder-driven to understand what worked in the last general election, what did not work well, and to inform necessary changes. The Commission has systematically used post-election evaluation to inform development of strategic plans and operation plans, which must be initiated and approved by the commissioners. Challenges arising from this thematic area is delayed reconstitution of the Commission members. And secondly, absence of commissioners to drive the preparation of the Commission strategic plan that informs necessary changes in its systems, structures, and processes. It is our recommendation that there should be prompt recruitment and appointment of members of the Commission using expert model recommended by Kriegler Commission as soon as the vacancies arise to ensure seamless implementation of their responsibilities as stipulated in Section 11A of the IBC Act. Further, the composition of the Commissioner should be in accordance with Article 254 of the Constitution and Section 6 of the IBC Act. Due to changes in the environment and the fact that the elections are largely technology-driven, the committee may also want to consider having at least one member with the technical expertise in information and communication technology. In addition, the Commission chairperson, being an advocate qualified to be appointed a Supreme Court judge, will propose an additional commissioner who is an advocate qualified to be a High Court judge to preside over legal legislated matters such as Electoral Code of Conduct Committee and pre-election dispute resolution. And also, we urge that the current practice of hiring and retaining core professionals and permanent staff to enhance institutional memory, as recommended by the IREC Commission, should be maintained. The second thematic area we want to touch on is boundaries limitation. Article 88(4)(c) and 89 of the Constitution of Kenya, Section 4 of the IBC Act 2011, mandates the IBC to conduct a review of constituency and wards boundaries. By dint of Section 2, Section 4C, Section 36, and the 5th schedule of the IBC Act, the Commission resolved all issues and completed the first review of the electoral boundaries in 2012. There were 27 constituencies which were protected in the first review. The upcoming delimitation exercise will rely on the Constitution of Kenya 2010, the IBC Act 2011, the County Governments Act 2012, the Urban and Cities Act of 2011, the Survey Act of 1961 revised in 2020, and the Statistics Act of 2006. The Commission proposed IBC Amendment Bill 2020 to streamline the new Section 36 of the Act to only prescribe the statutory framework for delimitation of boundaries and to provide comprehensive procedure in the 5th schedule of the Act. The Commission is expected to conclude the delimitation exercise by 5th March 2024. The challenges arising from this thematic area, members, is that there is policy, strategy, and operational uncertainty arising from delayed recruitment of chairperson and members of the Commission, and thus it is unlikely that the IBC will complete the review exercise on time. Further, there are gaps and ambiguities in the law, in particular Section 36, vis-a-vis the 5th schedule, which is already spent. In addition to that, there are emerging variation in population and area based on the population census and also on the computation of population quota. When we went to the field to collect the geodatabase, we saw that there are many sublocations, new administrative units that have been created that needed to be incorporated in the political boundaries. there are conflicting memorandums by various parties from the same region, basically indicating that there are disputes in those areas. Of course, coupled with this is budgetary gaps to undertake the limitation exercise, and possibility of protracted litigation after the boundaries limitation exercise. There is also risk of acrimony and violence during public hearings. Arising from this, the IBC recommends that there is a need to fast-track the recruitment of chairperson and members of the Commission, to review the statutory framework on the limitation of boundaries by providing exhaustive framework on the procedures for actual delimitation in the 5th schedule of the IBC Act, as reviewed in the IBC Amendment Bill 2021. The Commission should also be given 18 months to complete the boundaries limitation exercise from the date of appointment of the commissioners and members of the Commission, and this is informed by the time taken by the IIBRC and then completed by the IBC team. It took almost more than 3 years, and therefore the work that we have done currently is about 50%, and what is remaining requires commission members to be in place. So we think that it will not be possible to complete the exercise on time, and therefore we need to be added additional time. There's also a need to allocate sufficient funds to IBC to complete the boundaries delimitation process. The other thematic areas is on the audit of the 2022 presidential election. Article 101, 136, and 180 of the Constitution prescribes that the election of the Member of Parliament, President, County Governor, and members of county assemblies shall be held on the 2nd Tuesday of August in every 5th year in a single general election. It is important to note that the Commission conducts 6 elections through the same process on the same day and using the same officials. This translates to 1,882 elected positions. Further, disputes arising from election of the 6th elected position are subjected to due judicial process. The outcome of the judicial process for presidential election is supposed to be binding and final to the Commission and the petitioners. The suggested audit of the presidential election inevitably delves into the entire framework of dispute resolution arising from the presidential election. Now, pursuant to Regulation 11 of the Election Technology Regulations 2017, an audit of the entire technology was done by a reputable independent technology security firm in compliance with the law. Further, audit of the register of voters was carried out by an independent audit firm pursuant to Section 80 of the Elections Act 2011. The results of the polling session were openly counted, collated, and promptly announced by presiding and returning officers at various levels in the presence of media, observers, political parties, and candidate agents. At the closure of voting, verification of all the results were done at various tallying centers by agents representing the candidates and political parties, and copies of the same given to them. A thorough verification of the presidential election results was done at the Bomas of Kenya National Tallying Center for 6 days, with the participation of presidential candidate chief agents in the presence of the media and observers. This was done in accordance with the results management framework shared with the presidential candidates. The verification entailed forensic audit of the original presidential results from 34As delivered by the returning officers using magnifier and UV light for authenticity. The verified presidential results forms were used to counter-check results transmitted on the public portal and results with the presidential candidates chief agents. This was followed by an open and transparent tallying declaration of the presidential results and issuance of certificate to the president. The results transmission system successfully transmitted a total of 46,201 presidential results forms from the polling station, translating to 99.94 attainment rates. 14,232,862 voters were identified electronically for the 2022 general election, which translated to about 99.95% of the voters who turned out to vote. The Commission transparently provided a public portal for access of presidential results, which was accessed over 380 million times. In determining the 22 presidential election petition, the Supreme Court of Kenya carried out information and communication technology scrutiny and inspection. an inspection, tallying, and recount of sample presidential results from the polling stations across the country. The Supreme Court returned a verdict that the presidential election was conducted in accordance with the principles set out in the Constitution and election laws, and that the Commission attained the constitutional threshold set out in Article 138, sub-Article 4 of the Constitution. We submit that the Commission complied with all relevant laws in the conduct of the 2022 general election. Challenges arising from this thematic area is that the process of scrutiny of the election technology has not been fully defined in law. Absence of legal framework for handling presidential election disputes after determination by Supreme Court of Kenya. There is also absence of the chairperson and members of the Commission to carry out the audit of the presidential elections in the event that an audit is required. There is also high likelihood of further polarization and division in the country if this process is undertaken. A recommendation on the audit of the 2022 presidential election: there is a need for legal reform to develop a legislative framework to guide the process of scrutiny of presidential election results before the decision of the Supreme Court of Kenya. And finally, there is a need to fast-track the recruitment of the chairperson and members of the Commission who may be required to drive this process. The other area is on electoral legal reform. The Commission conducts election under elaborate institutional and legislative framework. During elections, the efficacy of the legal framework is tested. In the aftermath of the election, the Commission facilitates a post-election evaluation to determine what worked, what did not work well, and draws recommendations to inform the conduct of future elections. Some of these recommendations inform legal reform to address the identified gaps in law. Guided by the above process, the Commission has over time made deliberate efforts to have in place a robust electoral legal framework for the conduct of elections by generating and reviewing election-related legislations and submitting the same to Parliament for consideration. In the last election cycle, the Commission, for example, submitted the Election Law Amendment Bill 2020, Draft Independent Electoral Boundaries Commission Amendment Bill 2020, Draft Election Campaign Financing Amendment Bill 2020, Draft Election Campaign Financing Regulation 2020, Draft Referendum Bill 2020, and Rules of Procedures on Delimitation of Boundaries 2021 for consideration by Parliament. In addition, the Commission submitted a reviewed Elections Voter Registration Amendment Regulation 2022, Elections General Regulation Amendment Regulations 2022, Election Voter Education Amendment Regulation 2022, Election Party Primaries and Party List Amendment Regulation 2022, and Election Technology Amendment Regulation 2022 for consideration by Parliament. The draft bills and regulations were never enacted into law. So the challenges arising from this thematic area is that there is a late enactment of laws, and when they are done too close to the general election. There is also inaction of Parliament in passing the proposed laws. So a recommendation in this area is that the draft amendments to electoral laws should be fast-tracked in line with the IREC recommendation of 2 years before an election. Further, the Parliament should enact the proposals on the electoral reform in time. There is also need to operationalize the IEBC fund and actualization of special voting for polls officials and essential service providers. There is also need to amend legal framework to expand the period for hearing and determination of presidential petition by the Supreme Court from 14 to 30 days. And there is a need to enact a robust legal framework to facilitate citizens living outside Kenya to participate in the electoral process. The other area is, and this is on additional matters, members, allow me to finish them, security of election officials and related challenges. In every year, the chairperson, members of the Commission, staff, and service providers are subjected to adverse security threats and torture. During the preparations and conduct of 2022 general election, the members of the Commission, staff, and election officials countrywide were subjected to abduction, intimidation, harassment, maiming, profiling, murder, and loss of life. The climax of these insecurities were manifested on 15th August 2022 during the declaration of the presidential election results, where the chairperson, commissioners, commission secretary, and staff were assaulted in full glare of law enforcement officers, media, observers, and the general public. It is worth noting that to date, no one has been brought to book to account for the above transgressions. We submit that working for IBC should neither be death sentence nor a career grave. Recommendations to mitigate security challenges. There is a need to conduct a public inquiry into the murder, abduction, and intimidation, harassment, maiming, profiling, loss of life, and attack on the commissioners and staff. There is a need to acquire commission-owned headquarters. We want to call it Uchaguzi Center, to provide assurance and conducive work environment to enhance security of election officials and commission installations. There is a need to provide special allowance for members of the commission and staff to compensate them for the risk of exposures during elections. And further, there is a need to enhance security for members of the commission and staff before, during, and after election. We thought probably also we should tell you about the achievement of the commission, with your permission. And we want to say that the commission, as currently structured, has successfully facilitated comprehensive post-election evaluations since its establishment. The 2022 general election post-election evaluation was delivered in a record 3 months' time, thereby allowing timely changes to the structure, systems, process, and law governing elections. The Commission successfully conducted and supervised the 2013, 2017, and 2022 general elections. The Commission established a professional and permanent secretariat that has relevant competences, knowledge, and skills. Further, the Commission devolved its operations to 47 counties and 200 constituencies. It also successfully deployed election technology. It spearheaded electoral legal reform over years, thereby enabling Parliament to amend such laws. The Commission also successfully determined 324 disputes arising from registration of candidates and defended 124 election petitions filed against the Commission after the 2022 general election. The Commission formulated and implemented 2011, 2017, 2015, 2020, and 2024 strategic plans and their respective plans of operations to guide the Commission in the implementation of its 5-year electoral cycle programs. This transformed the Commission to a premier election management body recognized globally. The Commission also established a commission on-premise for Kenya Integrated Election Management System production infrastructure at the industrial area. During the 2022 general election, the Commission worked closely with the stakeholders in the observation of production of KIMS kits. In addition, the Commission collaborated with the stakeholders, including political parties and religious organizations, in the observation of the printing of ballot papers. The Commission established and deployed election management infrastructure in the country, including KIMS, BVR, CRMS, in compliance with Section 44, subsection 1 of the IBC, of the Elections Act. As a premier election management body, the Commission continues to receive benchmarking visits from various election management bodies in Africa, including Ethiopia, Botswana, South Sudan, Somalia, and South Africa, amongst others. The Commission has continued to receive invitations to make presentations in global electoral forums on various thematic areas. The IBC was highly lauded by both local and international observers on the conduct of 2022 general elections in their final observation reports. And in June 2023, the Commission was awarded ISO certification in its election technology. In conclusion, honorable members, we urge that the Commission be insulated from interference and its independence preserved as envisaged in the Constitution and democratic tenets. Indeed, Kenya's democratic practice will only continue to grow and mature over time if the parameters of our electoral conduct enhances the independence of the Commission. It is therefore a collegiate duty of all election stakeholders to preserve the sanctity of free, fair, credible, and secure elections. Furthermore, it is truism that the business of election democracy is a tough call, but it is a call that we must be willing to hit in earnest. First, because the Constitution demands it, and secondly, because the act of human history has adjudged it as the best form of government. I submit. Thank you very much.
Thank you very much, CEO. And now we can get back to our positions where we can see you. You have overshot by only 5 minutes, so you've done relatively well. We'll also strive to do relatively better in the questions. Please note the questions that members will ask and answer them maybe after one round. Maybe I could start. You have spoken about bills that you submitted to Parliament but were never enacted into law in the last 12 Parliament. Probably one of the issues that we've had is always doing election laws too close to the election. What is it that you are doing to make sure that you are following up the enactment of those proposed bills in the 12th Parliament, including issues like the extension of the timelines for consideration of presidential petitions from 14 to 30 days, and all the other bills that you listed there. And I do not think that particular proposal was ever captured in any of the bills that you had proposed in the last Parliament. Maybe you can appraise us as to whether now you have begun work on that. Then you've spoken about the August 15th incidents at Bomas. I would want to know whether your commission did file any complaints with the police out of the events of August 15th, and whether the public inquiry you propose would be in what form or format. Do you want a judicial inquiry? Do you want a police inquiry as to the events of August 15th and what you have described as a harassment and intimidation, including the murder of electoral officials, or is it a commission of inquiry that you are proposing? Two, on the reconstitution of IEBC, you've spoken volumes in terms of the urgency of the reconstitution of IEBC. I've not heard you as much as these are your bosses, or the people who come in to become your bosses. I've not seen any proposals as to the form you'd want this to take. And I ask that because the presenters who are before you also spoke to it, but they were shy of telling us any specific proposals as to how you'd want that IEBC reconstituted in terms of the current legal framework that exists, that we used in the last two general elections, or what was used previously in 1997 in the format of the IPPG, or what we have seen in other Commonwealth jurisdictions where the president appoints commissioners that he deems to be fit for that job. Maybe if you have any specific proposals, we'd be happy to hear. Members?
Maybe,
yes, Co-Chair.
Maybe just a follow-up, starting from where my colleague has left. There was the matter that was raised by the Supreme Court in its decision in Raila, okay, 2022. It observed that the decision-making processes of the commission, I'm just paraphrasing, were rather dysfunctional. What is your understanding of this dysfunctionality, and what would you recommend as measures to address it? Tied to that is what you referred to in your presentation, Mr. Majan, a little earlier, that you would vote for the expert model That is in terms of appointment of commissioners. The expert model that was recommended by the Kregler Commission. Could you expound on that? And again, tied to that is whether you still think that as we reconstitute the commission, we need to retain the idea of having in place commissioners on permanent basis, on full-time basis, or would you suggest an idea of commissioners on part-time? Finally, I'm just trying to be quick. Second last, actually, is the matter of the public inquiry that you have recommended, which I think is very progressive. But then, in terms of those members of staff who are abducted, tortured, intimidated, murdered, used all sorts of verbs and adjectives. If we are to institute this commission of inquiry, or this inquiry generally, how far should it go? Okay? And what form should it take? Because I say this out of sadness, recalling how the former commission, IBC staffer, senior staffer, Chris Musando, was abducted and murdered in 2017. He comes from my neighboring constituency of Kenya, and he was a close friend of mine, I must disclose. So would you help us understand what form this inquiry should take, and how far back should it go? Very finally, have you gazetted the IBC? Have you gazetted the results for the presidential vote of 2022 by constituency or on constituency or county basis, as is required by the law? Maybe you can help us understand what form the gazettement, if ever, if at all, has taken. Thank you.
Omar. Again, Secretary STC to the Commission, Secretary to the Commission, thank you very much for your presentation. I worked as a commissioner myself, and I know it's not the best place to be in, particularly the IBC. But I commend you that you bear courage. In fact, one of the presentations you asked was a question I wanted to ask. But starting with the same issue which Co-Chair and I had articulated, are you suggesting the Kriegler because it's the one you're familiar with? Or is it because it's a best practice situation? Can you give us other jurisdictions where commissions are, for instance, partisan, where they are elected or appointed on party strengths rather than the elaborate process? I know in a lot of jurisdictions, commissioners are appointed through a parliamentary process, particularly proposed by the presidency, including Nigeria and possibly South Africa. But I'm also informed of the Mozambican model, where I think they are appointed based on proportional party strength. So in this Kriegler proposal, as you expound on it, it is the basis upon which we gave birth to the panel. Do you think there is any basis for us to continue to recommend improvement to that process, or you think we just fill in the commissioners as were articulated in that? I think one of the things this committee might end up doing, will recommend various reforms or proposals towards improvement of that appointment of commissioners. And this issue of delimitation of boundaries, is it still your holding, based on the Supreme Court's verdict, on whether this is purely a function of the IBC, or do you think this committee has any role in the delimitation of boundaries? And I agree totally with the expansion of the time frame, because I think the deadline is March 2024. We might be almost too close to that to be able to ensure that we can do that in that time. Thirdly, before I come to my last question, my last observational question, after every successive presidential elections, some of the aggrieved parties have called for fundamental review or certain systems review of the IBC. These parties that were aggrieved, have they taken part either directly or through appointment of representatives? Or has there been a legal framework where they participate in the review of these systems? 2013, 2017, possibly now 2022. If there were a review of these systems, were these parties that were aggrieved after a presidential election, have they been party to those reforms that you have been doing? And if yes, why have you been stealing from the same person? Number three, the last one, which is the scope of the inquiry. Opio and I talks about how far back it should date. But for me, I want to ask you, do you think, there was a general reason as to why the government thought that we should move on and not belabor too much on the election injustices? One side believes they are the victims. We also believe we are the victims. There was a deliberate attempt to subvert the will of the people by using commission processes that will have been a total subversion of the will of the people, saying that commissions vote by virtue of majority. That majority cannot extend to subverting the will of the people. But in your estimation, there was involvement of the National Security Council, NSAC, which also tried to subvert the will of the people in the testimonies of your former chairman and in the testimonies presented before the Supreme Court. Are those testimonies also documented within the commission space? We had a Trump situation here in Kenya. Do you think a Trump situation where we now look at all those who are trying to sabotage our democracy through a public inquiry and then put them through a process of prosecution, do you think that is in the interest of the country? I agree to that extent where there has been murder, intimidation, killing of certain Kenyans. Those are crimes that have no, particularly murder, have no statute of limitation. So those must be looked into. But in terms of the scope of the inquiry, there were allegations of affirmed allegations of perjury at the Supreme Court, where one John Githongo was said to have produced fake documents. So what do you think should be the extent of in terms of the scope of the public inquiry if one should have, and should that mean that prosecution should follow?
To be brief in the interest of time.
I will end there. I will end there because I had
questions, not speeches.
Because this, for Mr. Chairman, was partly the crunch of why we are here, an attempt to talk about an electoral theft that never was.
I don't know whether what he has taken is too much, or you want to respond to those ones, or we just...
I think just to take you as noting.
Okay, so now my first question will speak to Article 138. If I can read 138.3c, it says, after counting the votes in the polling station, the IEBC shall tally and verify the count and declare the results. And I believe this is what you are doing in Bomas. Now, you know this process, progressive democracies, when we go through a crisis, we want to engage in a discussion and find ways of doing things better next time. Now, in your estimation, at Bomas, who was exercising the powers of tallying and verifying the count? Was it the 7 commissioners, or you as the CEO, you are the one who took the leading role, received the count from all the polling stations to the exclusion of the commissioners? And how best do you think we should do this? Should we relook at this Article 138C? Maybe empower your returning officers to do this at the constituency level so that we don't have the kind of push and pull. Because I saw you play a very central role in Bomas. We remove this pressure from you. How do we do this 138 Sabalco 3C in a way that builds confidence vis-a-vis your role as CEO and then the role of the commissioners. Then the next one will be on Article 81. You know, you have made a very scared statement on the last elections. You have said there was a lot of intimidation, killings, which generally points to the fact that maybe the elections were not free and fair. What was the impact of this intimidation? When you look at Kenyans, can you tell them the elections were free and fair? Or you will stand with what you have said, that there was a lot of intimidation and threats? Because really, if there were intimidation and threats, then we should be making a conclusion that the elections were not free and fair. The third one, and this purely is on ways of looking at whether the laws we have are serving us. We have mentioned about doing 6 elections in one day, and you have really said it's heavy. And I can confirm, I received my results after, I think, close to 48 hours, just hanging at the IBC. And I can see you have given figures. Now, do you, as IBC, because you are really the users, you are the ones who go through this, your staff, returning officers, presiding officers, do you think there is wisdom in maybe separating these 6 elections? I would like to hear the experience of IBC. Could there be a proposal that we maybe separate these elections? The issue of delimitation of constituencies. You did mention that the next exercise will be done under the 2020 Constitution without paying any regard to the schedule that was transiting. Is it your case that you will only apply the criteria that is in the current Constitution, and the idea of applying the schedule is now spent? I'd like to hear the views of the Commission. Then the issue of picking commissioners, the model, what Commissioner Hassan has stated. You know that some countries like the US, a state comes with its own laws on how to conduct elections. In a state, they finish and a count is made. That state picks the electoral commissioners and that is done. That is it. So do you think in Kenya, and I saw you say you have devolved IBC to the 47 counties. Following from what Hassan has said on looking at practices in other countries, including in Australia, where the states do elections and they do the counting at the state and it's done. Do you think we can also devolve this issue of presidential elections? We have a commissioner at a county, you have your returning officers, we get final results at the constituency. Once we get Nairobi, we know Nairobi is announced, it's gone to whoever is a candidate, RUTO, William, or Raila Odinga, or Kalonzo Musyoka. We finish it at the county level. And then finally, you know, we use a lot of technology in our elections management. And I saw in the run-up to elections, we had some companies. I think, was it called Smartac? What was the name? Smartmatic. And the other one, that were fairly discredited on their record. The record that they left behind in other countries where they had been engaged. Of course, we don't want a repeat of really engaging bodies that have a lot of integrity issues. Now that we are looking at the process, going back, Vanasio, do you think we didn't pick the right people to manage our technology in our elections of 2022? Maybe that should be enough for now, Chair.
Thank you. You have something, Governor?
Yes. I want to understand. You're saying that you would need 18 months to review the boundaries once the commission is fully constituted. Would that in any way affect the general elections in terms of inclusion of the new boundaries in the next general election? Number two, would you say you had a free and fair election under the circumstances? Are you able to confidently say the elections were free and fair? Number three, are the electronic data, is all the electronic data safe? And I've heard people saying open the server. Under what circumstances would you open the server? Is there a legal framework allowing for that to happen or not?
We take all of them, then he answers, we close.
Okay, thank you, Chair. The idea of the audit of all the 6 electoral positions should be treated as a single matter. Why all the time single out only the presidential one? And secondly, this is a proposal that has consistently come from the judiciary. I wish to get a clarification. Why do you propose the presidential period to be extended from 14 days to 30 days? Petition, I mean, to be extended from 14 days to 30 days. What exactly informs this position that it needs to be done like that? And I think the rest have been mentioned. Thank you.
Amina, do you have any?
Thank you, Chair. That's a good presentation from the IEBC team. My question number one, since are the records, including the servers, available for inspection and audit by independent forensic auditors? Then my other question is on the boundary delimitation. I would like to know what is the role of Parliament in that, and what preliminary work has been done so far. And finally, if IEBC can conduct delimitation on the counties. My question number 3, and I think this is a very thorny issue that has brought all of us here, is the question on the commissioners. The last general election, the commissioners did not agree on the presidential results. We had 3, I think 3 of them or 4 that agreed and the others didn't agree. So as IEBC, what is your take on that and how do we avoid that in future? Thank you.
CEO, just as you come in, that issue of IEBC, would you want us to still retain the 7 commissioners or we can increase it to the maximum of 9?
In the reconstituted commission.
Yeah.
Go ahead.
And you need to give us an indication of time you will take to answer them. Maybe. Is 10 minutes okay? 15? Yeah, everything is important here.
7.5 minutes.
7 minutes? Yes.
15 minutes. Very weighty.
These are very weighty questions.
For 10 minutes.
Honorable members. Yeah, so I would also want to be also supported by my able
feel free. If there's someone on ICT matters, your ICT director, if he's
yes.
more averse with them.
Yes. Now, if you allow me, I allocated the questions first before I.
Okay.
Yes. So the first one on the issue of what are you doing to ensure timeliness of the bills that have been enacted, the bills that have been amended and have not been enacted. What are we doing to ensure that they are timely enacted? That one will be done by Mr. Owiye. Whether the commission filed a complaint on what happened on 15th of August and what kind of inquiry would we propose? That one I'll try to handle that. How would you want IBC Commission to be reconciled? I think it's also to be reconstituted. Yeah. Whether we have got any proposal, I'll do it myself.
Why don't you answer the ones that you're answering?
And then the rest are okay.
Then
all right.
Yeah.
You insist that I should be the one to
yours. Start with yours.
Then
All
the rest you can pick or theirs.
Thank you. Thank you very much. And okay. So I'll start with the one that on the whether the commission filed any complaint on the what happened on 15th of August 2022. The answer is yes. We filed a complaint with the police nearby here, near Bomas of Kenya, and they took our statements. So that is actually what we did. We thought probably the best thing is to go and file a complaint on the same. So that one was done. Right away, we don't know what is the outcome of that process. I would have expected that because it's about fair administration of justice, those who are aggrieved definitely need fair justice to what happened to them. So that was a first step of this. And therefore, we thought probably
the straight answer is that you have filed a statement. You even recorded statements to the police who have not acted.
Yes, we have recorded statement, but nothing has happened so far. How would you want IBC Commission to be reconstituted? We have mentioned in our report that this structure was able to deliver. When we say structure, it means the composition of the commission as well as the structure of the secretariat. Right away, previously I've worked with three commission members. The first one was Isaac Hassan. There were 9 commissioners, and then now came the Wafula Chebukati. Initially there were 7, 4 left, and then 4 joined. And in that, the only difference I saw is that the fewer you are, sometimes you tend to make decisions very quickly and flexibly. The more you are, there is a lot of pull and push when it comes to decision making. But again, I think for such a weighty matter as election, the Constitution has been very clear in terms of the composition of the commission, because it also wants to see the face of the country and to make sure that it represents the national outlook. And therefore, we can actually grapple with that. Whether, because as a commission, we are, once the law has been prescribed, our role is to ensure that it is followed. The Constitution is the supreme law, and those articles that are there are supposed to guide us, and we are supposed to ensure that they're implemented. But in terms of practicality, I would say probably the fewer the commission members, in terms of making decisions, the better. Then there was, I think there was also something on a decision-making process of the commission. Seems to be dysfunction, especially after the rupture that happened at the Bomas of Kenya.
Before the rupture?
Before?
Yes, the entire process.
Yes, so you wanted to understand how does the commission works, and my simple answer is this: the way we work is that first of all, we are the proposers of the strategies and policies at management level. The process seems to be unpractically going bottom up, and then from there the commission are able to interrogate and make the right policies and strategies, that thereby after a resolution is made, we are now asked to implement those formulated policies and strategies. And in many instances where the commissioners are not in agreement with what we are proposing, they would actually resolve on what they think is right for the commission, and we would go with that. But management papers are being generated from the directorates, and they come to management committee. They are prosecuted. They are returned back if there are any issues. They come back. Once they are done, they are taken to subcommittee. We have got around 7 subcommittee of the commission that oversight various functions. Just to mention the few, there is one on ICT, there is one on finance and supply chain, there is one on election operations, boundaries and research. There's another one on human resource. All those ones are providing governance on various areas. So depending on the thematic area, they will be taken to a respective subcommittee, who will now also digest that. If they believe that it's actually now solid for it to be taken to plenary, where there is going to be all members of the commission, they will submit it themselves. And I will be there actually as a commission secretary. These commissioners will work with the directors, and the CEO will not even be present when they are discussing the same. I will only be appearing during management meeting, and therefore I will be having an understanding of what has been discussed and what are the things that we are proposing. At commission level, now the papers of the subcommittee are going to be subjected to a lot of discussions. And then after that, a resolution is made. Once it is made, now it becomes my role to ensure that they are fully implemented. And if there are any changes, then they are still brought back against the same process. So I think that even in terms of governance, that process works. When there are too many commissioners, of course there is pull and push, but ultimately, if there are any issues that are unresolved, they'll still also be voting. They'll be voting on those issues. I remember there was a time even when the commissioners voted on even to repeat the procurement of certain things. And those who actually took the show at that particular time, their view was taken. And the secretariat was now forced to implement the resolution of the commission. So that system is working, it is self-checking. But it will be self-checking if we have got competent people who have got an understanding of what the commission is doing. Because, for example, you can't put somebody to oversight ICT when that person has got no technical competence in that area, at least. So, for example, so when it comes to such matters, they solely just rely on what the secretariat is saying. If we have got somebody who is competent in that specific area, they can be able to understand and make informed judgment. So this is how the commission has been working. So ultimately, you will find that if there is any issue that is not agreed upon, either it is postponed to a later date for people to still go and think about it, or a resolution is made by majority will take the day. That is how the commission has been working. Now, it's only that now we were surprised, and to add it with now what happened at the Bomas of Kenya, we were surprised with that turn of the events. That at that particular time now, certain section of the commission now say we are not in agreement with the results. Even us as a secretariat, it was a shock. You also Chair, you also asked whether we could. We talked about in a submission. We talked about expert model. Whether we should explain what we understand by expert model. I think that is the question that you asked, Honorable Opio and I. That is the question that you asked.
That is true.
Yes, yes. So I want to say that our understanding of expert model by Kriegler recommendation is that the commission should be made up of experts, and they will be recruited by a panel. And therefore, there's going to be independence in terms of who actually determines the people who are going to be members of the commission. And then ultimately, they are going to be appointed. Whether it is going to pass through Parliament for it to be scrutinized and ultimately the President to approve, that is a process, is another process. But we are saying that it should be strictly be expert. And those experts should be done in a competitive way, like what has been happening. You advertise, people, they send their submission for them to be considered. They are interviewed, and then after that, the best is basically picked. As opposed to IPPG, in IPPG, political parties were allowed to select members to be members of the commission. So when you do that, it basically interferes with the independence of the commission. More or less what you are trying to say is that you are trying to inoculate politics into management of the commission. And you would want the commission to function independently. Have you gazetted results for presidential results? I would want Mr. Uye to respond on that. Can I continue with mine first? Yes.
Just finish yours.
Yeah.
Apart from Mr. Uye, who else is going to answer?
Also, Deputy C is going to answer.
Okay.
Then also Michael is also going to answer.
Okay.
And probably also Director Sonkuli in charge of elections operations. You asked about, I think this question was asked by Honorable Hassan Sarai on looking at various models. And I think the question is whether we consider Kriegler as the best model. Have we looked at other jurisdictions where the commission has been functioning, and which models have they used, and whether with what has been happening in Kenya, do we think that we should actually maintain the same model, or we can look at a different model altogether? If you ask me, I will be biased, because I will tell you that this, and I said it before, that this structure has worked. You know, dismantling a structure that has worked, it will be, for lack of a better word, it will not be good. Because this is something that has won, you can only be able to improve on it. Is there anything that you can be able to do to improve on it? Yes. But there are other jurisdictions also whereby, for example, if you look at Indian model, there are only 3 commissioners who are working there on permanent basis. If you look at, for example, Ghana, I think Ghana, it has got a chairperson and 2 vice chairperson, and then other 4 members are not permanent. They are temporary. They only come on a need-to-do basis. All those ones have been working depending on the dynamics in the environment. Kenya environments may not necessarily be the same. So we understand better our environment. You people understand better our environment. And I want to believe that here we are looking for a solution on which composition should actually make the commission work better. This also should also be coupled with the question that Honorable Opia and I also asked, that should we then have commission on temporary basis or on permanent basis? Which one would you recommend? And this one also,
part-time versus full-time.
Yes, part-time versus full-time.
Or a hybrid.
Yeah. Yes.
Hybrid is
or hybrid. And also this one I would want to also, my colleague also, to also throw in their thinking, because it's not about the commission. It's about what do you think about that? Personally,